Hello, and thank you for joining us for our webinar. Before we begin, I would like to cover a few housekeeping items. To ask questions, please use the Q&A widget on your screen. We will try to address questions throughout the webinar. Otherwise, we will get back to you via email. For those seeking CLE credit today, please download the affirmation form and the evaluation form found in your resources widget on the screen. We will announce the CLE code during the middle of the presentation. Please return both forms for CLE credit. The presentation and the materials will be available for download from your resources widget. And we will also distribute these via email after the webinar. So you're joining Rule 15a-6. Non-U.S. broker-dealers will provide some background and current issues. This is Marlon Paz. I'm a partner at Mayer Brown. I head the broker-dealer practice. Perhaps of note related to my background, I was at the SEC for a number of years. And I guess most relevant to the issues we'll cover today, I was one of the drafters of the last proposed rule amendments to Rule 15a-6 back in 2008, of which I will discuss, and of which I think the SEC staff is sick of hearing me say how much that rule proposal needs to be adopted. Not just because of the pride in authorship, a number of us work very hard on updating Rule 15a-6 for good reason, as I think I'll discuss in a moment. And as I hope many of you that are joining agree, but it continues to be a rule of great utility, even if we have stretched the original adopted rule to its limits and perhaps beyond. So very much appreciate you joining, and we'll dive in. I will say at the outset, because of my background as a adjunct professor at Georgetown, and then I've taught at a number of other schools, I'm used to interactive settings. So please, chime in with your questions. I will be monitoring the widget with the Q&A. So I will try to get to your answers as quickly as I can, but I think this will make it a more interesting presentation for all if you participate, and that way I make it as relevant to you as possible.
So Marlon, if I could cut you off, I'm sorry to cut you off.
Yes.
If people are not seeing the broker-dealer presentation in their browser, just refresh your browser and then it should show up. I know some people had some problems, but go ahead, Marlon.
Thank you. Yes, and please do let us know through the Q&A if you're having any difficulties. We are monitoring, and again, we want to make this relevant to you. So as we launch into a conversation about Rule 15a-6, let me go back to what is true today and has been true for some time, and that is one of the most significant trends in the financial services industry, certainly during the last several decades, but probably going back to the 60s during a commission that was established in 64, which acknowledged as much. There has been an increased demand for foreign investments by U.S. investors. And that has been coupled with the continuing internationalization and interconnection among local securities markets and market intermediaries. The U.S. Treasury Department publishes statistics on the amount of foreign investments by U.S. investors and the amount of U.S. investments by foreign investors. And both have seen tremendous growth year over year. I commend you to look at those statistics, but I would note that in the context of that increased demand, both inbound and outbound, the ability of U.S. investors to deal directly with foreign financial service professionals is limited by the U.S. legal and regulatory structure. Before anybody thinks that I'm criticizing our regulatory structure here, I would note that there's good reason to provide limits. And I'm not one that advocates throwing away these important protections. But much like the SEC has done, and back in 1989, certainly the SEC recognized that this growing internalization of the securities markets and the broad scope of registration provisions of, the SEC could yield to some exemptions for foreign broker-dealers to help facilitate limited contacts with persons physically located in the U.S. I will tell you that the pace of internationalization in the securities markets around the world has continued to accelerate. And that is undeterred even now as we experience global pandemics. We recognize just how interconnected our capital markets are. And that interconnectedness requires, indeed mandates, more careful attention to Rule 15a-6, which at the moment is difficult to provide comfort given that the rule from 1989 is and has been quite a bit dated and is subject to a patchwork of guidance and interpretations. Similarly, advancements in technology and communication services have provided greater access to the global securities markets for all types of investors. And so the demand for foreign investments really goes to Main Street. And that is, of course, of greatest concern to the regulators. And maybe it should be, but we ought to think of a way to provide for investment in foreign securities and foreign investors to access our capital markets in a way that is consistent with the tripartite mission of the SEC, of which many of us believe very soundly in. I would note that the U.S. employs a territorial approach in applying the broker-dealer registration requirements to the international operations of broker-dealers. So the financial institutions around the world where they engage in brokerage activity and where that brokerage activity touches the U.S. means or instrumentalities of interstate commerce, the 34 Act requirements attach. So under this approach, broker-dealers that are located outside of the U.S. that induce or attempt to induce securities transactions with persons in the U.S. are required to register with the SEC unless they have an exemption. So this is where Rule 15a-6 comes in. They're required to register unless there's an exemption. I will pause here momentarily to note that the concept of broker-dealer is in many ways, each day more and more unique to the United States. Many countries around the world have financial institutions which engage in commercial banking and in investment banking. We happen to have, because of historical events, had a distinction between the two, and that is applied in our regulatory scheme. Nevertheless, note that this territorial approach is particular to the brokerage activities, and so we refer to those activities as broker-dealers, and when they are outside of the U.S., foreign broker-dealers, even if that concept or that nomenclature doesn't exist in that locality. I've been asked that question often, so that's why I wanted to make sure I pause there for a moment. So, register or be exempt. Where is that registration requirement? Well, you will find it in Section 15a of the Exchange Act, which provides that absent an exception or an exemption, a broker-dealer that uses the mails or the means of interstate commerce to effect transactions in or induce or attempt to induce the purchase or sale of any security must register with the SEC. Just to answer a question that's come up, yes, we will make the slides available after the presentation. The term broker is defined in the Exchange Act as any person engaged in the business of effecting transactions in securities for the account of others. There are about 11 exceptions for certain bank activities. Dealer is similarly defined in the Exchange Act as any person engaged in the business of buying and selling securities for his or her own account. Again, there are exceptions for certain bank activities that you will find in the Exchange Act and which have been added to the legislation. Well, today we are discussing one such exception, Rule 15a-6. Near and dear to my heart, Rule 15a-6 provides conditional exceptions from broker-dealer registration for foreign broker-dealers dealing with U.S. investors. Now, while the rule has provided a useful framework for U.S. investors to access foreign broker-dealers, it's been, several decades and increased market utilization that strained the original framework, and today the rule requires careful analysis of SEC staff guidance. Apologies, we seem to have a repetition of some of the slides here. There we go. Okay. So let me just go through some of the provisions of Rule 15a-6. I'm going to come back to some of these to put a gloss on it with the available guidance and interpretations. Okay. So paragraph A1 is the unsolicited trades or the unsolicited exemption. What does that mean? Well, it exempts broker-dealers, exempts foreign broker-dealers from registration to the extent that that financial institution affects transactions in securities with or for persons that have not been solicited by the foreign broker-dealer. A big note of caution here. The SEC interprets the phrase or the word solicitation very broadly. However broadly you can imagine it, go broader. And that will serve to keep you in the right side of compliance. It includes any affirmative effort to establish a business relationship or to induce a trade. For example, if you look at Release 25801, the word solicitation means any affirmative effort by a broker-dealer intended to induce transactional business for the broker-dealer or its affiliates, whether a single transaction or an ongoing securities business relationship. Pay careful attention to the use of websites. Most financial intermediaries these days have a website. And so there are implications where that website is in English or can be, deemed to be aimed at the U.S. and it uses the means or instrumentalities of interstate commerce, such as the telecommunications lines, fiber optic lines, you may be triggering the territorial application. Those of you that are seeing the slides related to ADRs, please refresh your browser, and you should be able to see the 15a-6 slides. Apologies for the technical difficulties. I will try to speak a little slower in case the audio cuts off for any of you, but please continue to let me know through your questions if there are any issues. So I would say that the unsolicited exception under paragraph A1 is of extremely limited utility. There is some permitted activity, so I don't want to just be all bad news. It is relatively not used, or I don't want to say useless, but very few use it. But I will tell you that the range of permitted communication that does not constitute a solicitation is extremely narrow. Certain confirmations, account statements, or issuer announcements. But be careful, because if that includes any advertisement inserts, you're back in. So a straight confirm with no follow-up, perhaps. Take a look at the frequently asked questions that the SEC staff has issued. You know, I've interacted with the SEC staff since leaving. Again, I keep asking them to you know, devote some bandwidth to adopting Rule 15a-6 proposals, which I think have to be further modernized at this point. But March 2013, we worked on a round, and I think those have been further updated, April 2014, and at other times. Take a look at those when it comes to unsolicited trades, because the term solicitation continues to be a very broad one. You will note, and you will read very carefully there, that the SEC staff expresses great skepticism over the ability to use Rule 15a-6a1. You should approach it with that mindset. Now, I would also tell you that I have witnessed the effects of increased global mobility by individuals. So, you know, you may have, you know, German residents, and I'm just speaking Germany here, or just pick a country, that desires to retire in Florida. And they've had a long-standing relationship with a bank in Germany, and they want to continue that relationship, but they want to retire in Florida. Now, if that German bank wants to continue that relationship, there is some consideration as to their ability to continue that if they do not have a registered broker-dealer in the U.S. or a relationship that permits them to be exempted from the registration requirements. So, okay, I think you get the point. Unsolicited trades, very difficult. It's a very tough standard. Research reports. So paragraph A2 exempts from registration foreign broker-dealers that furnish research reports directly or indirectly to a category of persons called, and here's the first definitional phrase, major U.S. institutional investors. And of course, there are certain conditions. Major U.S. institutional investors includes institutional investors with assets in excess of 100 million and registered investment advisors with more than 100 million under management. The phrase U.S. institutional investors means registered investment company, a bank, savings and loan association, insurance company, a business development company, or an employee benefit plan as defined in Reg B. Now, it permits the provision of research reports, and thus may be disseminated directly by the foreign broker to major institutional investors or through a U.S. affiliate. Now, recall that in the U.S. we have Reg AC, but that continues to apply. And distinguish third-party research from research for which that U.S. broker-dealer, the one distributing, takes responsibility. Further, take a look at some of the FAQs. You know, there are some required legends and you know, some guidance that has allowed you know, global firms to take advantage of their global operations. Let me turn briefly to perhaps the most often used provision of Rule 15a-6, and that's the so-called chaperoning provision. Paragraph A3 provides an exemption from the registration for broker-dealers that induce or attempt to induce trades in securities by major institutional investors and institutional investors So long as any resulting trades are effected through a US BD and various conditions are met by both the foreign BD, the associated persons of that BD, and the registered broker-dealer that affects the trade. Very important exemption, widely used and subject to quite a bit of interpretation by SEC staff, guidance, and I think those of us in private practice have continued to utilize A3 in favorable ways. Note that this so-called chaperoning provision requires that contact with U.S. institutional investors directly may be done only if an associated person of a U.S. registered broker-dealer participates in each of those contacts in person or electronically. That includes all communication. So it really makes the BD, the U.S. BD, responsible for the content of those communications. So there is a supervision hook. There are books and records. FINRA's 3110 applies, and the sales practice rules attach. This is all in an effort to protect the U.S. investors. Now, direct contact with major institutional investors may occur without as much participation. So there's a bit of disintermediation there, and I'll talk about some developments there in a bit. In both cases, though, the transaction must be effected by a registered broker-dealer. That trade financially has to go through the U.S. broker-dealer. Okay? Books and records have to go through the U.S. broker-dealer. So let me be a bit more crisp here. The USBD has to issue all the confirms, the 10B10 confirms, the account statements. It has to be responsible for any extension or arrangement of credit. They have to obtain copies and retain under 17A4 copies of all consents, the service of process. Okay? The U.S. regulators, the U.S. authorities need to be able to get books and records, need to be able to get jurisdiction over the issues here if they need to protect investors. They need to have someone on the hook for the financial liability, the books and records, and someone that has in mind compliance with the customer protection rules, the communication rules, and so on. Now, in order to avail themselves of this paragraph, the Form BD has certain requirements that they have to comply with, such as submission to the jurisdiction of the SEC, not be otherwise barred, and agree that the activities have to be conducted through through a U.S. broker-dealer, and that they otherwise will conduct those activities from outside of the U.S., unless, of course, they're chaperoned or they're able to deal with major institutional investors under certain circumstances. By a no-action letter, which I'll refer to in a little bit, some of these developments have been modified and extended by the SEC staff. And while it is a no-action position, it is a class no-action, and one that I think has almost taken the shape of law. At least many of us have great comfort in them. There's a question which I'll read out loud, and the question is: are there any U.S. BDs that offer chaperoning services to foreign BDs as a separate business line? And the answer is yes. There are actually several broker-dealers whose main business line, or perhaps their only business line, is to serve as chaperones to foreign BDs. I think that you can find a pretty easy list if you just Google 15a-6 broker-dealer or something like that. But yeah, there are, and FINRA recognizes that there are U.S. broker-dealers who are in the business of facilitating these transactions between a foreign financial institution and U.S. major institutional investors and U.S. institutional investors. And there are agreements that are fairly standardized at this point. I think my agreement, our agreement here at Mayer Brown, looks very similar to the standard used around in the industry as to what that agreement looks like between the foreign BD and the U.S. chaperoning BD for these purposes. Okay, I'll come back to chaperoning in a bit, but let me just round out 15a-6 with 15a paragraph A4, which permits the foreign financial institution to effect transactions with or for registered BDs, banks acting in a broker capacity, and thus dealing with U.S. investors through any U.S. broker-dealer acting in an agency or dealer capacity. Okay? So 15a-6A4 is very powerful. Note that paragraph A4 also permits foreign BDs to transact with certain international organizations, supranationals, as sometimes they're referred to, the World Bank, Inter-American Development Bank, and others, regardless of their location. It also permits those foreign financial institutions to transact with foreign persons that are temporarily present in the United States and with whom that foreign BD has a pre-existing relationship before the foreign BD, before the foreign person entered the U.S. Let me say that one again, because I think I want to, we get a ton of questions about this one. So a foreign financial institution, let's take the German bank that I mentioned at the beginning of the hour, may continue to transact with foreign persons that are temporarily in the U.S. with whom that foreign BD, the German bank in my example, had a pre-existing relationship before that person entered the U.S. So this is the example of, a German bank that has a client that desires to vacation in Florida or desires to go to school in Florida and or relocate for their job for 2 months in Florida, take a training course. They're temporarily present in the U.S. They're not going to have a green card. They're not going to be, they're not relocating to the U.S. They're vacationing. They're on holiday, and so they're here. The question is, can they continue to interact with that person? Yes, they can. 15a-6A4 permits that. It also allows foreign agencies or branches of U.S. persons located outside of the U.S., provided those transactions are effected outside of the U.S. And with respect to non-resident U.S. citizens, so you've got a U.S. Citizen that lives in Italy, an Italian bank can deal with that U.S. national, so long as the transactions occur outside of the United States. Okay, 15a-6A4 is actually a very powerful aspect of 15a-6, perhaps not as noticed as 15a-6A3. Many people think 15a-6 and they automatically go to chaperoning. I think it's important to view the totality of the rule because it does provide quite a bit of important relief. A question that comes up and has been asked, so I'm going to read it out loud, is the division between the use of 15a-6A3, the chaperoning provision, and A4. I would say that A3 is by far used much, much more often. But once larger financial institutions understand the availability of A4, that provides a more streamlined approach to accessing U.S. investors, particularly where they're dealing with foreign securities and they're dealing with clients with whom they had a pre-existing relationship. But I think that by and large, many of the services that are provided by U.S. broker-dealers and chaperoning, those are done under A3, and that tends to be the higher, number in transactions as well as monetary value of the transactions. But A4 has gained quite a bit of prominence recently as people have discovered its use. As I mentioned, there have been important subsequent developments after the '89 adoption of Rule 15a-6, which, as I mentioned before, really had its roots, I would say, back in the '60s. And so, the availability of an exemption has been building up for decades. But already in '89, the commission recognized. Sorry, my slides here got a little out of whack. Okay, I'm back. Already in '89, the commission recognized the need for a rule, and almost immediately, the industry recognized the limits of that rule. Well, I'll mention a couple of letters that have become extremely important. The first one is colloquially referred to as the 7 firms letter, and that's because there were 7 firms that requested it, but really it was, it's considered class no action. And that was issued in 1996, January 30th, 1996. And the SEC staff permitted foreign affiliates of U.S. registered BDs to effect transactions in foreign securities with U.S. resident fiduciaries for the accounts of offshore clients. So that's a mouthful, okay? So you've got an affiliate of a U.S. registered broker-dealer, and they want to effect transactions in foreign securities, but they're doing it for a U.S. fiduciary, a U.S. investment advisor, that's managing an investment fund. Could be a registered or unregistered investment fund. And the investors in that fund are all offshore clients. Now, the fund itself, the person doing the trading, is a U.S. person. And therefore, it triggers the U.S. territoriality provision. And the person affecting the transaction happens to be a foreign, broker-dealer affiliated with a U.S. registered broker-dealer. The SEC said that in those circumstances where it's an affiliate of a U.S. broker-dealer that affects transactions in foreign securities with U.S. resident fiduciaries, and that it is for the account of offshore clients, they may do so without registering, as long as they effect those transactions in accordance with 15a-6. Okay. So that's the 7 firms letter. Now, remember that the reason we're talking about the 7 firms letter is because a U.S. resident fiduciary ordinarily would be viewed as a U.S. person, but this provides comfort and relief. So it was deemed to be an important development. Well, not too long after that, in 2003, the SEC provided another no-action letter, this one called the 9 firms letter, which provides further relief to foreign broker-dealer affiliates of U.S. registered broker-dealers that permits, now, notwithstanding the chaperoning provisions that I mentioned earlier on A3, certain, expanded abilities. So they can interact with any entity, including any investment advisor, even if it's not registered. So, for example, managers of hedge funds that own or control in excess of $100 million, as though those are major institutional investors. It also allowed for the clearance and settlement of certain transactions in foreign securities to occur through direct transfers of funds and securities between the foreign BD and the U.S. investor, as long as the foreign BD is not the custodian of the funds or the securities of the U.S. investor, and that the foreign BD agrees to make available to the U.S. BD, any books and records related to that transaction. And of course, that foreign BD is not in default to any counterparty. So we want to make sure we protect the financial conditions here. Now, this was necessary because certain foreign securities could only be cleared and settled by members of exchanges in that foreign jurisdiction, which, was the foreign BD, not the U.S. BD. Also, in the Nine Firms letter, the foreign associated persons could make some visits without being chaperoned. They could engage in oral communications from outside of the U.S. with institutional investors, outside of regular trading hours of the New York Stock Exchange, as long as they didn't attempt to affect transactions and securities. And they were allowed to have other in-person contacts with major institutional investors and others covered by the Nine Firms letter, as if they were major institutional investors. Okay. Now, those contacts could not exceed, 30 per year or so. I tried to update that in the 2008 proposal, but we're still in proposed form. Distribution of quotations, for example, was also greatly facilitated, and there was an ability to provide on-screen quotation systems to supply greater access to information about those foreign markets. Also something that we tried to address in the updates in 2008, of which I will discuss in a moment. So those are important glosses on Rule 15a-6. I will note that there were certain amendments done to Rule 15a-6, so not everything has been static since '89, but by and large, these amendments do not change the character and the nature of Rule 15a-6. Gramm-Leach-Bliley Act, which modified the definitions of broker and dealer, which used to exclude banks, but after the Gramm-Leach-Bliley Act, made it so that banks would be accepted from the definition if they made certain conditions therein. So paragraph A41 of Rule 15a-6 permits foreign broker-dealers to engage in certain activities with a, quote, bank acting pursuant to an exception or exemption from the definition of broker or dealer in the provisions that were modified by Gramm-Leach-Bliley. I don't think this is a hugely substantive, change, but I want to make sure for the sake of completeness that you understand that there were some changes announced. As I mentioned, I worked in 2008, and many of us, I think some folks are having trouble with audio. We'll try to fix that. And we'll definitely be able to replay this presentation. Back to the 2008 proposed amendments. So the SEC proposed amendments aimed at enhancing the ability of U.S. investors to access non-U.S. securities markets and to promote the globalization of the capital markets. Now, you recall that around 2008, much like we are experiencing today, we began experiencing a financial crisis, or we were in the middle of a financial crisis. So a lot of the important work that had been developed up until then. Now, before 2008, we were hearing a lot about the competitiveness of the U.S. capital markets and how we were losing ground to the U.K. and a number of other jurisdictions. All of that gave way in the flood of the financial crisis, and much of the bandwidth was devoted to dealing with the stress in the capital markets that we were all experiencing then. Nevertheless, these important changes that were proposed by the SEC in 2008, I think remain very important, and I hope that they get some attention. I know that we're dealing with some very difficult issues with the global pandemic, and I don't mean to minimize those issues. I pray that we all get through that soon, but I do hope that we also find a way back to dealing with these improvements to a rule that is so important in global commerce. The proposed amendments dealt with a qualified investor standard. We've got several, and we've added some more through no action letters. So who's a qualified investor? For example, this issue of unsolicited transactions, so the third-party quotation systems, which were also part of a no action letter. Currently, the unsolicited exemption doesn't really permit much of that. So the 2008 amendments were designed to deal with some of that. The provision of research reports was also addressed and enhanced. And the issue of solicited transactions, the chaperoning provisions, were designed to bring into rulemaking that which had been doing, with the advent of staff guidance in the form of no action letters. Furthermore, transactions with certain specific counterparties and customers was enhanced. As I mentioned, paragraph A4 is a very powerful aspect of the rule, and I think it has very logical underpinnings back to the creation of the initiatives, long before the 80s, I think it goes back to the 60s. But transactions with, registered financial firms in the U.S., banks, broker-dealers, but new categories too. So offshore clients, the offshore client concept in the no action letter in 1996, and foreign resident clients, for example. So you've got a German national that doesn't just decide to vacation in the U.S. They decide to relocate to the U.S. So they're a resident, but they remain a German national, and they want to continue their relationship with a German bank. Foreign options exchanges were also the topic of the proposed amendment, as well as the scope of the exemption. I'm going to pause here to read the CLE code. I know I've been a little delayed in reading it to you, so I'll pause here. The code is 04, M as in mayor, B as in Brown, 14, B as in broker, D as in dealer. That's 04, MB, 14, BD. I've thrown a lot of background your way, and I wanted to take a moment to distill some of that in a chart form, which I tend to find useful. And if you're visual like me, I hope you do as well. But there are a number of important concepts that are sometimes difficult to keep together and align here. And so I thought that I would put them in a chart format in case it is useful to you to see what the Rule 15a-6 and related no action letters provide. Oh, sorry, somebody wants you to repeat the code here, 04 MB 14 BD. Okay, so here's what I've done. Again, I hope you find it useful. Please ask questions if you still have some uncertainties about it. This is not a rule that is intuitive, largely because it is the province of a lot of lore and the developments that have occurred since. But I thought, let me put what the provision of 15a-6 on the left column, and then which security does it apply to? That's one of the important aspects of it. Is it a domestic security, a foreign security, any particular type of security, and who the foreign broker-dealer's counterparty can be. Any U.S. person, some U.S. people, and if so, who? How do you differentiate? And any transaction requirements related thereto. Okay? Again, I hope this provides a useful cheat sheet. It's not complete in its interpretation, but I don't think that the current state of Rule 15a-6 lends itself to completeness within the rule. You really have to look beyond the rule to really understand the contours of Rule 15a-6. So the unsolicited exemption, we talked about it, paragraph A1. It applies to any security. That's pretty wild. And any U.S. person, including retail customers. Again, pretty wild. But as I mentioned, this is extremely narrow. And there's great skepticism at the SEC as to whether this can be used at all. And so be very careful with this one. It involves no solicitation. It must involve no solicitation. And that is very difficult to achieve today. It is a very broadly defined concept that includes just about any contact. I can't stress that enough. A2, research, well, you can deal with any security and it has to be a major U.S. institutional investor. Most of the research, though, is really related to foreign security. Okay? But those research reports cannot recommend the use of a foreign BD to affect the trades. So you can't use it as advertising. And that foreign BD cannot initiate other contact. Okay? So, of course, 15a-6a-3 is there, but 15a-6a-2 just allows for the provision of research reports that do not recommend the use of the foreign BD to affect the trades. It is therefore not as attractive to people unless they couple it with an affiliated BD in the U.S., registered BD, or a chaperoning relationship with a U.S. registered BD under 15a-6a-3. Okay, so let me now move to chaperoning, and I'll spend a couple of slides here, okay? The 97, letter and 15a-6a-3, okay? So this is the 7 firms letter. Deals with U.S. institutional investors, and there are certain transactional requirements. Solicitation is permitted with some constraints. Transaction must be effected through the registered BD, and the registered BD has a number of requirements. Here are some of the key aspects, at least in the development. Communications during in-person U.S. visits. Lots of questions about that. So during in-person visits in the U.S., the foreign associated person must be accompanied by an associated person of the registered BD. And that registered U.S. BD accepts responsibility for the foreign BDs, for the foreign associated person's communications with the U.S. institutional investor. Further, any transaction in securities discussed during the visit must be effected through the registered BD. What about any other communications? Okay, any other communications of foreign associated persons are permitted to engage in unchaperoned oral communications from outside of the U.S. with U.S. institutional investors, where such communication takes place outside of the trading hours of the New York Stock Exchange, as long as the foreign associated person does not accept orders to effect transactions other than those involving foreign securities. Otherwise, all oral communications between foreign BDs and U.S. institutional investors must be chaperoned by an associated person as a registered broker-dealer. Okay. Very important. Now let me move here to major U.S. institutional investors. You'll notice that the requirements are modified, and particularly communications during in-person visits are permitted unchaperoned, okay, with major institutional investors as long as the number of days in which such in-person contacts occurs does not exceed 30 per year. I tried to up that in the 2008 proposal. Let's see if it ever gets adopted. Otherwise, those in-person visits must be chaperoned. And remember, any transactions still have to be effected through the U.S. registered broker-dealer. There are no other restrictions on communications between the foreign BD and a major U.S. institutional investors. So that's a really vastly modified improvement. Let me get to some of the other aspects. So when you're dealing with a foreign security or U.S. Treasuries, major institutional or institutional investors, all the requirements of A3 must apply, except that clearance and settlement may occur through direct transfer of funds. So clearance and settlement, when it comes to treasuries or foreign securities, may be done directly between the foreign BD and a U.S. investor. Okay? And where you're dealing with a foreign security, U.S. resident fiduciaries for offshore clients, remember I mentioned that? You have to obtain written assurance from the U.S. resident fiduciary that the account is managed by an offshore client, is managed for an offshore client, rather. So not enough to have the Cayman fund, but, make sure it's for offshore clients. A4, deals with any security, and when you're dealing with, registered broker-dealers, banks, or supranationals, you're in the clear. So, question on is it 30 days or 30 visits? And is it per person or per client? That's a very, very difficult question to answer. And let me throw one more gloss here. So it's 30 days. And there is at least a large number of staff at the SEC trading and markets that believes that it's 30 days total for the entire firm. I think that interpretation may be given way, particularly for large financial institutions. So, because you may have different associated persons of that large financial institution visiting the U.S., and then you're going to get to 30 really quick. It's counted as per associated person, but I think that the 30 days, would have to be analyzed depending on the firm to determine whether it's 30 days, tacked on per associated person to the firm, or if it's 30 days per associated person, such that a firm has many different attempts to visit. So if they have 2 associated persons, that'd be 60 days, for example. I think that the more conservative view is that it's 30 days total. So so be careful with that. And another clarifying question here, a very good question. I'm going to pause for it. The $100 million threshold for major U.S. institutional investors, is that committed capital, which may not have been called, but have been funded. It's a question of interpretation, and I don't want to speak to conclusively here, but we have been able to get comfort where the capital, has not been called, so committed capital may be fine, but it depends on the obligation to be able to call on that capital. So if there are contingencies, I think that the SEC staff will not see that as $100 million in assets. So that offshore fund, for example, which is where I've seen that come up, where you have a U.S. resident fiduciary for an offshore client or an offshore fund. If that is $100 million in AUM that is not quite committed yet and is subject to a lot of contingencies, they may not give you that ability. So happy to discuss those scenarios with so much specificity offline. But yes, it can be counted by looking at the committed capital. Okay. A4, foreign persons temporarily present in the U.S. If you have a pre-existing relationship and the person is temporarily in the U.S., look at the snowbirds exemption from Canada. I've extended that a bit further into other scenarios. And yep, any security, foreign person temporarily present, more comfort if we're dealing with foreign securities. Just to give the CLE code once again, 04MB14BD. Okay, I think we're close to out of time here, so let me just talk about some current issues. Please take a look at the SEC's frequently asked questions page on 15a-6. It may seem dated, but it's actually, I think, some of the most current information available. I, because of my involvement in the rulemaking in 2008 and my charge while I was at the commission and focus on this and international issues, continue to monitor it. So always happy to chat with you, but do follow that. I think that particularly with a rule that's this dated and this old, a lot of what the rule means and how it's applied is no longer contained in the text of the rule. And I understand for those of you aficionados of good agency rulemaking practices in the Administrative Procedures Act, that may offend you, but that is the state of the law, that is the state of the world when it comes to this particular rule. I think it would be borderline malpractice to not look at those other interpretive guidance and further release it. Take a look at the FAQs. I think these are important. Also, note that there's been quite a bit of enforcement throughout the years. Every single year, there's at least one or two actions that touch on 15a-6. Okay? So, Bank Lumi, for example, in October 2016, 200 persons resident in the U.S. were solicited. That's about a $1.5 million fine for failure to register. Other large banks, several of them are clients, where they provided private banking services to U.S. clients out of Switzerland, or private banking services, out of the Canadian, or Swiss, affiliate. We're also subject to some fines. FINRA has been active as well. So FINRA has a case of failure to ensure proper confirmations delivered by a foreign affiliate under 15a-6. So even when you've got that relationship, make sure that you are complying with the contours of Rule 15a-6. We've got a couple of questions that have come in. Let me try to see if we can address some of those. So foreign salesperson that needs to qualify under 15a-6, must they provide information to the chaperoning U.S. broker-dealer regarding any personal violations of local securities laws, even if it's not permitted under U.S. privacy laws? I'm paraphrasing here the question, but the short answer is, not the specifics, but the U.S. broker-dealer needs to know whether the foreign associated person meets, and whether the foreign bank or the foreign broker-dealer meets the requirements of 15a-6, and that doesn't always translate to providing information that would be subject to, for example, EU privacy laws without consent. But it does translate to providing the information required to make the understanding or the representation that they do or do not represent. So in a typical 15a-6 agreement, such as the form that we have, there is a representation that must be made. That doesn't require the provision of information protected under EU privacy law, but it does require the representation to be made as to whether the person meets or does not meet the requisite exemptions or conditions for reliance on 15a-6. Let's see, I'm looking at other questions here that have been coming in. Yes, the no action letter will be included. They're actually cited in the presentations, but we'll include them in the materials that will be available to you. And then I've been asked for some guidance or expectations for U.S. chaperones participating in in-person client meetings with a foreign affiliated person. Yep, those U.S. chaperones are responsible for the content of that communication. So, you know, that chaperone becomes a supervisor, in effect, of that communication and must be very careful to ensure that the sales practice rules are, ensure compliance with the sales practice rules, and that, you know, the communication with the U.S. investor or in the U.S. is done in a manner that comports. And for that, I would look to FINRA rules. And now, as of June, I would start looking at Reg BI to ensure compliance there. So excellent questions. Thank you, everybody, for participating. I know we've just scratched the surface. There's a lot of questions we can continue to go through here. And unfortunately, though, we are about a minute past our time. We will try to hold another one of these, but my hope is that one of these days we'll be talking about an adopted update to Rule 15a-6, and that fine piece of work from 2008 can get picked up, improved, given the further development. And I look forward to working with you in some of these difficult issues. Thank you for tuning in, and appreciate your questions.